Copyright is a negative right, enabling you to prevent others from copying or using your creative output without your permission. In the UK, copyright comes into being as soon as a work is created. It is automatic. And there are three main categories of copyright relevant to you. Musical works, the songs you compose, their melodies, bass lines, arrangements. Literary works, the lyrics you write. And sound recordings. Aside from the song itself, there is a separate copyright for the sound recordings of it. As UK copyright is automatic, there are no legal forms to be filled in, but it is wise to keep a record of when and how you created your works, just in case you are challenged to prove it when you become mega famous. Particularly as a single song or sound recording can comprise many different copyright works owned by different humans, all squeezed together. For example, you write some lyrics. That's a literary work. Copyright arises automatically, owned by you, the writer, without having to fill in any legal forms. A singer takes those lyrics and creates a catchy melody. That's a musical work, owned by the singer, without having to fill in any legal forms. The keyboard player jams along, creating a nice chord progression over that melody. That's another musical work, with another owner, again, no forms. The sequence of the song is then set with an arrangement by another person, which also counts as a contribution protected by copyright, and eventually the song is finished. A patchwork quilt of 4 different copyright works from 4 different creators, all glued together within a single coherent song. If you're a one-person singer-songwriter, life is simpler but lonelier. You're the only creator, you own all the copyright. In bands, it can get complicated. Even if the one person writes the whole song and everyone plays what they're told, they may well add their own minor tweaks and interpretations as they perform the song, but they are not actually writing it. They are being told what to play, and the real author and owner of the copyright is the songwriter. Or are they? This is murky territory, where the courts have literally had to intervene to establish the difference between writing and tweaking, which I thought was a Miley Cyrus song. When does a tweak become a significant contribution? We touch on the gory legal details in 2 case studies in our PDF available in the bio below. Stewart versus Barrett confirmed that to get a share of the copyright and be recognized as a joint author, you have to make a significant and original contribution to the creation of a work pursuant to a common design. To own copyright, you have to create something original of your own that makes a significant contribution to the song. What counts as significant is assessed on a case-by-case basis. So a tricky thing to clarify at Band Practice 4 Pints In. It may not always be clear to all who actually create the song, let alone who owns the copyright. We'll talk about the benefits of band partnerships later in this vid. Once you decided who owns the copyright in the song and in what shares, you'll play the song in the studio while engineers make it sound tight and make a number of sound recordings of the song. This requires skill, time and resources, which is recognized by a separate copyright in each sound recording. The owner of the copyright in sound recordings is the person who undertakes the necessary arrangements to make the sound recordings. It's the person who ultimately makes the recording session happen, usually the one who organizes and pays for it. In legal speak, this person is called the producer. They are not to be confused with the studio engineer or your mate who makes beats. If you write the lyrics and melody for a song, but you're not a great singer, you might bring a session singer in to perform it. You record them singing your song in the precise way you ask them to. Do they have any rights? Yeah, but it's not copyright. They've not created the song in any way. They did not write the melody or lyrics. They own no copyright. They are purely performing, meaning they enjoy separate performers' rights, which enable them to prohibit the unauthorized recording, making, or distribution of copies of recordings of their performances. I know your mates are going to laugh at you, but if you're using session musicians, you should get your forms out and get them to sign something giving you the consent you need. And you should pay them too. I don't know whether the law counts a pint and some Jaffa cakes as payment. If you're thinking, whatever, you might end up heartbroken. See our PDF to A, realise what an amazing pun that was, and B, see another terrifying music law case study. This time Henderson versus All Around the World. If you are the session musician, I hope I've been clear. You have rights, even if performing on a recording for a mate or lover. They shouldn't be recording or releasing your performances or making any money out of it without you having had the chance to say whether or not you're happy about it. An oft-repeated bottom line in these music advice videos: if they're making money, you probably should be too. The music industry has historically been split based on the difference between copyright in the composition song and copyright in the sound recordings. Record labels acquire the rights in the sound recordings and publishers acquire the rights in the song. To re-emphasize, copyright is a negative right, the ability to stop people from doing certain things which the law calls restricted acts. The acts restricted by copyright include copying the work, pressing up copies and stuff, performing the work to the public, playing a song in a pub, communicating the work to the public, putting a sound recording on YouTube or Spotify. If anyone does these things without the consent of the copyright owner, they will infringe copyright and the owner could sue them for damages. Music contracts tie up the rights to do the restricted acts. A record label generally asks you to sign a contract that authorizes them to use and exploit the sound recordings of your songs. They might ask for ownership of the recordings or just for the permission to use the recordings. They will usually ask you to promise that you are actually the owner of the copyright and haven't just copied it from someone else. They will agree to give you a share of the income they make from exploiting your sound recordings. Might probably ask you not to record for any other labels for a certain amount of time too. A publisher is after the rights in the underlying compositions. In a publishing deal, you give away the copyright in your compositions so that the publisher becomes the owner and can collect publishing income from mandatory license fees required for the performance or reproduction of the song. In return, the publisher will usually pay you around 60 to 70% of the income they generate. Many music contracts involve 1. Handing over ownership of your copyright works to other people. 2. You giving permission to use your copyright works. They frequently include references to assignments or licenses. It's vital to understand the difference. With an assignment, you transfer ownership of the copyright. The person you assign the rights to becomes the new owner and can exercise all the rights of the owner, including over you. You have effectively sold your baby. A license is different. A license grants permission to do certain things for a certain amount of time that would otherwise infringe your rights. You've effectively lent your baby. To do a deal that gives a label the permissions they need, but not handing over full ownership, you give them a license to use and exploit your sound recordings. This will cover exclusivity, time period, and territory, amongst other things. Our PDF outlines the key points in more detail. If you work together with other musicians, it is advisable, understatement of the year, to agree the ground rules in advance. If you can reach agreement on how the band operates, plus the rules between you, you'll know where you stand and you can focus on the music, hopefully preventing arguments arising in future. At the very least, reducing the legal costs. Our PDF outlines the things you should consider in a band partnership agreement. If you don't create one, you're going to be stuck with the standard legal rules that apply to partnerships in business. Risks here include you being liable for the debts of another band member. No one wants to have to pay for their egomaniacal lead guitarist wah-wah pedal. Let's wrap this up. In a future vid, we're going to talk in detail about your first contract. For now, I hope we've given you a good feel for the key things to look out for. Copyright, it's automatic, no forms to fill out, but if in doubt, get it written down. Lawyers are not cheap. Doing it for the love. It's great. It's what we love and encourage here at Nusic, but it don't pay the bills. If the other dude or dudette is getting paid, you should be too. Wherever possible, license rights rather than assign them. That is critical. And remember, it really helps if you're fucking good.